This is Dan Krause from Krause Estate Planning and Elder Law Center, a friendly law firm. And I want to tell you today a little bit about the amount that a community spouse is able to keep during a Medicaid crisis for their spouse. So where you have one spouse that's well and another spouse that needs care in a nursing or assisted living facility or maybe extra nursing care at home, the community spouse is allowed to keep a certain amount of assets in the countable assets in Medicaid. Before we go into that, I just want to tell you that the friendly law firm does estate planning, wills, trusts, powers of attorney, healthcare documents. We do elder law, which includes Medicaid planning and helping people to preserve their assets through the need for nursing care. And we also do probate and estate trust administration, which is helping people pick up the pieces after someone passes away and get on with their financial lives. So, a couple of weeks ago, I talked about the resources that someone is allowed to keep if they are going on Medicaid. Basically, the difference between countable and non-countable assets and the amount of countable assets that you are allowed to keep. So as a refresher, a person is allowed to keep $2,000 in countable assets and no more if they are going to qualify for Medicaid to pay for their nursing care or assisted living. If there is a couple, though, the well spouse or the community spouse is allowed to keep up to $130,000, which is graduated every year. It changes depending on the cost of living increase, and they publish that number usually in December for the next year. So that's good news. The community spouse is allowed to keep up to $130,000, but it could be less than that. Now, the formula that's used in order to calculate how much the community spouse is allowed to keep is just half of everything that you start with a maximum of $130,000 and a minimum of $50,000. So if you start with $260,000 in countable assets or more, the community spouse is allowed to keep $130,000 of those assets, and the spouse that needs the care is allowed to keep $2,000. So that's a total of $132,000 between them. If the person if the couple starts with less than $100,000 in assets, then the community spouse is allowed to keep $50,000 because $50,000 is half of $100,000 and $50,000 is the floor. So for example, if a couple started with $70,000 in countable assets, the community spouse would be allowed to keep $50,000 because half of $70,000 is $35,000, which is less than the minimum. So the community spouse is allowed to keep the $50,000 in assets. I hope this has helped you understand a little bit about the asset limits that are allowed for a couple in a Medicaid case in Wisconsin. Each state is different, so I caution you, if you live in a different state, please check with your own rules and regulations in that state. But if you live in Wisconsin, this applies during the year of 2021. Of course, this number changes every year, and it could change with different legislation. If you have questions about Medicaid qualification or saving assets upon entering nursing home, please give us a call, 608-268-5751, and I'll see you next time.